You're at home enjoying your Sunday evening, you get a knock on the door, someone wants to serve you with a lawsuit, you've been served. What do? Stay tuned, we're gonna talk about it. Look, credit card debt is up. They're coming after people. They didn't get a lot of money during the pandemic. So let's talk about what happens when you get a lawsuit from a credit card company, how you defend yourself, what your options are. I'm with PandA Law Firm. I'm one of the founding partners over here. And what we basically do on a day-to-day is defend people against debt, right? And help save people's homes from foreclosure. I want you to understand that we're primarily barred in Nevada. Every state has different laws, so if you're in a different state outside of Nevada, you might want to go talk to local counsel there. One of the most important things when it comes to a lawsuit is not ignoring it. A lot of people try to duck service, evade, process servers, things like that, so now you don't really have notice of what's going on. That lawsuit is going to continue even if you ignore it. So, overarching theme, do not ignore it, do not delay, take timely action, and that way we can resolve it with as little damage as possible to you. A credit card lawsuit is where you have a credit card debt. For some reason, you stopped paying it or you couldn't pay it. And now that credit card, after trying to collect it, couldn't get anywhere. And so they filed a lawsuit, normally in a small claims court jurisdiction in the city or town in which you live, right? And so they're trying to collect it through the judicial process, called a lawsuit. Some of the reasons why they sue, like we talked about, was if you stop paying it. I mean, that's the primary reason. Oftentimes people will try to talk to the credit card companies before it comes to lawsuit, right? They'll try to settle it on their own, or they might hire a debt settlement company to try to settle it. And if they cannot settle it within a certain amount of time, then you'll see a lawsuit. And generally speaking, you can see lawsuits within 2 years of being behind. Sometimes it takes a little bit longer. Lawyers are notorious for suing right before the statute of limitations expires. Statute of limitation is the time period that any plaintiff has to sue before their claim expires, and then they have a defense that they have to overcome. So in some states, it's 6 years, like Nevada, it's 6 years from date of last payment. They have to sue within that 6-year period. If not, you have a great defense. So although they normally will sue you within that 2-year period, it might be up to 6 years on a written contract. If you had hired a debt settlement company to resolve this issue for you, and these are non-law firm debt settlement companies, so ones that don't call themselves law firms or ones that don't practice in your state, even if they do call themselves law firms. If you get sued while you're in that debt settlement program, oftentimes they'll drop you as a client in regards to that account, or they might try to refer you out to some local attorney that'll take on the case, but you're normally not going to get top-notch service there. In fact, a lot of those cases end up getting referred to us. So just understand that if you're doing some kind of debt settlement to resolve your credit cards, it's probably best to hire a local law firm in the town that you live. If you like what you're hearing so far, please like, comment, subscribe. And then if you have specific questions that you'd like to ask us, you can go to www.pandalawfirm.com. You can pose questions there and we'll answer them. You can pose questions in the comments and we'll do our best to address those as well. If you ignore the lawsuit, well, here's what can happen. They can get a judgment against you. And once they get that judgment against you, they can garnish your wages. In Nevada, that's up to 25% of your net income. Let's say if you take home $1,000 every paycheck, these guys can get $250 from you every paycheck, right? And during that time, costs accrue, interest still accrues. Your employer has now been advised that you've been sued and that you have a judgment against you. Not a good look, right? So that's one thing that can happen that can really destroy people's lives. 2, they can clear out your bank accounts. They can freeze them up to the judgment amount, right? They can find out where you bank and then hit those bank accounts. They can put a judgment essentially on your personal record. So judgments are public knowledge, right? So when you try to refi a home or buy a car, although the judgment is not going to show up on your credit report, it is public knowledge, and these lenders can look to see if you have a judgment against you, and oftentimes that will stop you from refinancing a home or buying a home. We see it all the time. That personal judgment alone will stop the refi or the purchase. And then sometimes people will try to hide judgments, right? Not tell a lender that they have a judgment against them when they're applying for something because it doesn't show up on the credit report. Now understand that might be considered bank fraud, which is a felony, so we don't want to do that either. So it's best to tackle these lawsuits before they become judgments, but even if you have a judgment, it's best to try to resolve it as soon as possible. So when you get a lawsuit, and like I said before, we're just talking Nevada right now, every state has different laws. You'll often see a 20-day deadline to respond on the summons, right? So the lawsuit is really two documents, a summons, which is your notice, and the complaint, which is the actual lawsuit. So the summons will say you have 20 days to respond. You should respond within that time period if you can. But if you cannot, you actually have a little bit longer. That's kind of an artificial deadline that's set out by the courts to keep cases moving. You probably have about 3 to 4 months, at least in Nevada, before that lawsuit will become a judgment, what's called a default judgment. When you don't respond, they'll get a judgment by default. So you definitely want to respond when you get notice of intent to take default judgment, which is normally like a 5-day period. You can still respond in that same time period. The other thing that I often hear is people say, well, Judah, I never got served with this lawsuit, right? You know, we had talked about people kind of evading service, evading notice. Well, in Nevada, and this is probably for most states, there's really 3 ways that they can serve you with a lawsuit. 1, hand you the lawsuit, hey, you've been served with this lawsuit, you need to respond. 2, serve someone who's above 18 that resides with you. And then 3, if the plaintiff cannot reach you, then they can serve you via publication, which means they're going to put your name in the legal notices section in a local paper for 4 consecutive weeks, let's just say. And at that point, now you're constructively served. Well, who reads those legal notice sections? Nobody, but you can get served that way. So if you avoided that personal service, and then they serve you via publication, where you're never going to know that you were actually served with a lawsuit, which can then get you a judgment, right, really quickly, because you're not going to know what's happening. So once again, let's take the service when someone knocks on the door and says, hey, look, you know, are you Joe Blow? Yeah, I'm Joe Blow. Take the complaint, and then we can handle it. So let's go back and say that you've received this complaint. You've now, service has been accepted. Well, what can you do? Well, if you're going to handle this on your own, you can often go down to the local courthouse. They'll have self-help centers there where they'll have pleadings, forms that you can fill out. And there's really 2 ways to respond to a lawsuit. 1, an answer, where you either admit, deny each allegation in the complaint, and you'll just file that answer, right? And that's your response. Or you can file a motion to dismiss, which normally don't win, right? But if the plaintiff has set out no claim, no cause of action, no theory that they can win upon, then the court might say, you know, we don't have to go any further. Plaintiff, you can't win anyways. You know, Joe Blow, you're going to win on a motion to dismiss. So you can pick either one. If you file a motion to dismiss, you can still file an answer afterwards if you lose that motion to dismiss. If you file an answer, you cannot later file a motion to dismiss. Now, once that initial procedural process goes through, the answer or the motion to dismiss, if you don't win on that motion to dismiss, then there's going to be something called the discovery process, which is where you exchange information with the plaintiff. Sometimes you'll get deposed. They'll take an interview under oath of you, and you can depose the other side as well. These things can get very complicated, very costly, very timely. For most small claim cases, what's going to happen is once you file that answer or motion to dismiss, you're going to have a Judge Judy style hearing, and you'll plead your case, your defenses, and the creditor will also plead their case. Then the judge will decide, sometimes right then and there. Sometimes they'll decide to take it under advisement and then give you a written judgment later. If you're involved with this, and you know, if you're trying to prepare yourself for that hearing date, then we need to think about, well, what kind of evidence do you need to gather? Well, I mean, that's dependent upon what your case theory is. You know, is this your debt? Oh, it's never my debt. You know, I never use this card, or it's in someone else's name. It's not my name, that kind of thing. If you dispute the charges, perhaps you're going to show them a history of your payments, or an accounting of how the charges came in, or that you didn't use it, or that you had reported fraud earlier. But you need to gather that evidence because it's your job to provide the defense. Even with that statute of limitations defense, let's say that you think it's been over 6 years from your date of last payment. That's something that you need to plead affirmatively. You need to say, hey, judge, this is past the statute of limitations. Here's my time of last payment. You can see it's been over 6 years before they filed that lawsuit, and so I should be let out, right? But that's something you need to affirmatively plead, is what they call it. Should you hire a lawyer to help you with this? Well, there's an old adage that says a person that represents themselves has a fool for a client. And that really means is that sometimes you're so involved emotionally in this, you can't make good decisions, or there's something you don't know, right? It's the wise person that knows what they don't know. So for me, myself, I've been a lawyer for 20 years and I have several businesses, and sometimes I hire other law firms to help me with things. Although I could do it, Maybe I don't have the time, maybe I'm not an expert at it, or maybe, like I said, I just cannot divorce myself emotionally from this. And court cases, hearings can sometimes be emotional or stressful, so we need to keep that in mind. But also we need to keep in mind, well, what's the cost of a lawyer? If you do have questions about that, right, then contact a lawyer. Oftentimes they do have free consultations, and you can really understand what your rights and remedies are at that point. The other thing that a lawyer can do, instead of defending the lawsuit, right? They could file a bankruptcy for you. We've talked about this in other videos, but you could file a Chapter 7 bankruptcy, which would wipe out the debt. You could file a Chapter 13 bankruptcy, which is a reorganization repayment plan. But the important thing to know is, as soon as you file that bankruptcy, that lawsuit stops. It's something called an automatic stay. So the federal bankruptcy court trumps state courts and a lot of federal courts too. So once you file that bankruptcy, something called a stay goes in place. That local lawsuit stops and probably would go away, at least in a Chapter 7. So we had talked a little bit about when to gain or gather or seek out professional help. Well, if you're unsure of what to do, that's a good reason, right? If you don't trust yourself with what to do, that's a good reason. If it's a large lawsuit, then oftentimes lawyers can save you money despite upfront costs when it's dealing with lawyers. Those are all good reasons to seek professional help. At PandA Law, when we're defending lawsuits or when we're trying to settle them, right, the first thing we're gonna do is look at a client and say, hey, is bankruptcy a better option for you than settling or defending this lawsuit? If it is, maybe we go that route. If it's not, then oftentimes we can settle these cases for pennies on the dollar, and that's with the legitimate threat of a bankruptcy. So oftentimes people listening to this video will contact the creditor and say, well, I'm gonna file a bankruptcy. And that creditor is gonna say, well, who's your bankruptcy lawyer? Right? Give us their name and number and we'll reach them. And then the Joe Blow debtor will say, oh man, I don't really know. So not a good position because you've lost all credibility right there. When I'm contacting a creditor as a lawyer at a bankruptcy law firm, I'm telling that creditor, look, Joe Blow's hired me to do a bankruptcy, and that's what I'm gonna do unless we can come to a reasonable settlement, right? Or I'm gonna defend this lawsuit, or I'm gonna make it really hard, creditor, for you to be able to garnish wages or lien bank accounts or lien homes, right? And that creates uncertainty on behalf of the creditor. That uncertainty is what's gonna give us leverage to settle that case for less. So just some key points to remember in conclusion here. Number one, do not ignore lawsuits. Do not avoid service of process. It's always better to know because then we can address it. Number two, respond in timely manners, perhaps within the 20 days, oftentimes that you're given to respond, but at least within that time period when you get that notice of intent to take default judgment. If we're going to settle a lawsuit, it's less expensive if we do it before they get judgment. It's most expensive and maybe even impossible if they're already garnishing wages or liening bank accounts because creditors just won't settle at that point and then we just have the bankruptcy option. So act timely, be aware, do not stick your head in the sand. That's not gonna benefit you. It's only gonna turn out worse. If you have any questions, I urge you to seek legal advice. Perhaps that local lawyer will know the local procedural laws better than you, and they may even know that opposing counsel, their law firm, or that lawyer, and sometimes even have a personal relationship with them like we do at PandA Law with local creditor law firms out here. So I thank you for your time today. If you like what you heard and you want to hear more, please like, comment, subscribe. We're happy to answer questions in the comments as well. And until next time.